Good evening. Welcome to the February 24th, 2022 meeting of the Kern County Planning Commission. Madam Chair, please call the roll.
Commissioner Ashley?
Here.
Commissioner Judge?
Here.
Commissioner McGiffney?
Here.
Commissioner Skidmore? Here. Commissioner Sprague? Mr. Hall? Here. Mr. Murphy?
Here.
Ms. Slayton? Here.
Thank you, Madam Clerk. Are there any commissioner announcements for this evening? Seeing none, we'll move to the approval of minutes.
Motion to approve minutes from February 10th, 2022.
Second.
Voice vote. All in favor?
Aye.
Aye. Minutes are approved. Item D, cases withdrawn or requests for continuance. Mr. Murphy?
Good evening, Commissioners. Thank you, Mr. Chairman. We have one item that staff is recommending a continuance. That is case number 2. This is track number 7392. Our applicant is Anil and Naru Mehta by McIntosh and Associates. The staff recommendation is that your commission continue that project until your March 24th, 2022 hearing. That completes the items that are being recommended for continuance at this time.
All right. Thank you, Mr. Murphy. Do I have a motion to approve consent agenda and the item to be continued?
I will make a motion to approve the case of withdrawn, item number 2, as read into record.
I'll second.
Real quick, I'm sorry, Mr. Chairman, not withdrawn, but to continue until March 24th.
Okay, so I will correct my motion. Cases to number 2 to be continued until March 24th, not withdrawn. Thank you for the clarification.
And I will once again second that motion.
Call the vote.
4 ayes, 1 absent. Motion carries.
Thank you, Madam Clerk. And moving on to item F, public presentations. This portion of the meeting is reserved for persons desiring to address the commission on any matter not on this agenda and over which the commission has jurisdiction. Speakers are limited to 2 minutes. Please state your name and address for the record before making any presentation. Do we have any public presentations for items not on the agenda this evening?
Mr. McGiffney, you did skip
Yes.
item E.
It was a consent agenda? I thought
That was, that
Oh,
was just for the case of withdrawn.
my mistake. Okay, now okay, consent agenda, I'm sorry. Mr. Murphy.
Thank you again, Mr. Chairman. So item E, consent agenda. These are items which are scheduled before your commission, which are being recommended for approval by staff, and the applicant has been informed of any special conditions and has no objection. The hearing on these items may be expedited if no member of the commission or audience wishes to comment or ask any questions regarding the case. This evening we have one case on consent. That is case number 1. Case number 1 is modification to conditional use permit 2, map number 158. Our applicant is the South Kern Compost Manufacturing Facility by South Kern Industrial Center, LLC. This project is located in the western portion of unincorporated Kern County, generally east of South Lake Road and south of Santiago Road. The request before your commission this evening is a modification of conditional use permit for the existing composting facility to increase the types of compost feedstock accepted at the facility, to install new equipment and that would be used as part of the pre-processing and post-composting operations, which include but are not limited to the addition of grinders, electrical screens, etc. That would all be designed to improve composting efficiency and compatibility. The project also includes an increase in the pile heights from 15 feet to 20 feet, and then an increase in the storage time of all finished compost product from 7 days to 180 days to accommodate several seasonal markets and to be consistent with the other regulatory permitting requirements. The staff recommendation is to certify the environmental impact report, adopt the section 15091 findings of fact and the section 15093 statement of overriding considerations, adopt the mitigation measure monitoring program, approving the modification to the existing conditional use permit as recommended by staff, and approve the new conditional use permit as recommended by staff, all in accordance with the recommended conditions, and adopt the suggested findings as set forth in the attached draft resolution. That completes the reading of the consent calendar tonight.
Thank you, Mr. Murphy. Do I have a motion to approve this continued case? excuse me, the new case, this is a new case, on consent.
I would move to approve the consent item as read into the record.
Before I second, Mr. McGivney, will you ask if the public would like to pull any of these items off consent?
Okay. Is there anyone in the public who would like to pull this particular item off consent? I'm seeing none. Again, we have a motion and a second, I believe.
I will make the second.
Okay. So we have a motion and a second. Please call the vote.
4 ayes, 1 absent, motion carries.
Motion carries. Mr. Murphy, this has a right to appeal, I believe.
It does. Thank you again, Mr. Chairman. For projects where the Planning Commission action is final, which includes this case, those actions are subject to an appeal to the Board of Supervisors by any interested person, and no development proposed by any application may be authorized until after the final date of appeal. That appeal may be filed with the Kern County Planning and Natural Resources Department, located at 2700 M Street, Suite 100 in Bakersfield, with a filing fee of $540 on forms we have available at the department and that are located on our website. That filing must be made within 14 days of and including the date of today's hearing.
Thank you, Mr. Murphy. Now I'll hopefully be able to move to public presentations. Item F. Portion of the meeting is reserved for persons desiring to address the commission on any matter not on this agenda. Are there any members of the audience who would like to make a public presentation for any item not on the agenda? Please come forward if that's the case. If not, seeing none, we can move forward to new cases. Mr. Murphy.
Thank you again, Mr. Chairman. We have one new case that is on the agenda for this evening to discuss. This is legal nonconforming number 1, map 113. This is a request to consider vested mining rights for the existing Old Dutch Cleanser mine site. The site is located in a property zoned A1MH and is located approximately 2.5 miles east of the intersection of State Route 14 and Red Rock in Kern Road, approximately 16 miles southwest of the city of Ridgecrest. Our applicant for this particular project is Matcon Corporation. All right. So again, the project before your commission this evening is a request for a hearing to consider the vested mining right status for the existing Old Dutch Cleanser mine site. As I previously mentioned, that project site is approximately 280 acres and is located 2.5 miles east of the intersection of State Route 14 and Red Rock in Kern Road, all located in eastern Kern County. The site itself is surrounded by the Red Rock Canyon State Park. The applicant for this request is Matcon Corporation, Inc., and Mr. Joe Matheson will be providing your commission with comments later this evening. Before we get into the specific details regarding this specific request, I think it would be important to discuss mining regulations in California in general. So first, mining operations in California are all regulated by the Surface Mining and Reclamation Act of 1975, which is better known as SMARA. So when it comes to SMARA, there are 3 requirements that need to be met to legally operate a mine in California. First, you have to have a mining entitlement. That is done through either a mining permit or through a vested mining right status that has been established on a project site. The second item is that you have to have an approved reclamation plan, and that must be in place. The reclamation plan is the plan in which the site will be reclaimed once all of the mining operations have finished. And then finally, the third item are the appropriate financial assurances. So that is the money that is held by the county just in case the project site operator or applicant fails to reclaim the site. There are financial assurances in place that the county could cash those in and then have the site reclaimed. So those 3 requirements, a mining entitlement, an approved reclamation plan, and financial assurances, all must be in place and approved prior to any mining occurring on site. So when it comes to mining, and this term vested rights, that is a legal term that when applied to mining means that the identified site would be classified as a legal nonconforming use and that the original mining application always intended to mine the entire site. So generally speaking, staff and the requests that we get for vested mining rights when it relates to an existing mine has been a continual operation, and they generally are requesting a determination that the remaining portions of a property not being mined have the right to be mined in the future. So like, for example, imagine if you have a 100-acre mining site, of which 20 acres are currently being mined. That site has an existing reclamation plan and financial insurances in place, and the request would be for a vested mining status on the remaining acres of land which have been continually owned by the mining entitlement holder. Again, that is most of the type of vested mining rights cases we get and that are applied for. The circumstances under this particular project are a little bit different, and so I'd like to go through and kind of expand on how this is different than similar cases that have come before your commission before. So in the case of the Old Dutch Cleanser project site, it has always been a 280-acre site, and Matcon Corporation is not at this time requesting to expand any boundaries of that project site. They're requesting a vested right status to mine within the boundaries that were previously established on this site. So that is one item in which this case differs from other similar requests. I would also note, for your commission's understanding, that this mine site has had 11 different owners throughout its history, and then Matcon and/or Joe Matheson have owned the site on 5 separate occasions. So regarding the project history, our records indicate that yes, the project site has been mined historically. However, the mining that has commenced on this site has been sporadic, and it has varied throughout the history of the project site. So we know our records indicate that mining did occur within the project boundaries between 1923 and 1947. Between the years 1947 to 1976, and then again from 1976 to 1989, is kind of an unknown history in terms of how much mining has occurred, how often did it occur, was it continual, was it not continual? We don't have specific information in our records to justify or to have evidence that it had been continually mined throughout those time frames. In 1989, the Kern Board of Zoning Adjustments approved conditional use permit number 1, which authorized mining to occur on the entire project site. And as part of that consideration process, both a reclamation plan was approved and at the time financial assurances were provided. However, between the years 2007 through 2010, a notice of violation and an order to commence reclamation was sent to the owner at that time due to the fact that the mine had been deemed abandoned under the provisions of SMARA due to project site inactivity. Now, I would note that, as I mentioned before, there have been 11 different owners, and Mr. Matheson and Matcon have not necessarily been the project applicant and the manager of the mine throughout this whole time. But again, we look at the site and its history, and it doesn't necessarily relate to who the actual owner or operator was at that time. But between the years 2007 and 2010, enforcement proceedings were conducted, and it was staff's determination and the state's determination that the project site had been abandoned due to inactivity on site. Ultimately, reclamation did not occur because the owner notified staff of their intent to continue mining, and they submitted a revised SMARA plan, which was being processed by staff under conditional use permit number 8. So basically, after that initial enforcement discussions occurred, it was indicated to staff that, no, we did want to, or the project applicant at that time did want to continue mining, and so they began the process again to re-entitle their mining rights. So between 2010 to 2014, this went back and forth as staff was preparing the appropriate information to process the request. In 2014, a mitigated negative declaration was prepared for the proposed conditional use permit, and it was circulated for public review. In January of 2015, the project itself was brought forward for consideration by the Kern County Planning Commission, at which point the item was referred back to staff for the preparation of environmental impact report due to comments that were submitted during that hearing and leading up to that particular hearing. So the other part that I can definitively say is that operator reported quantities indicate that no mining activities have occurred on site since 2008, so the past 13, 14 years. So based on the history of the project site, it is staff's determination that there is not sufficient evidence that has been submitted to us by the project applicant that would allow staff to determine that the project site itself qualifies for a vesting right status under the existing state law. First, we did not have evidence, or there's not evidence in our record that had been provided to us that showed that the site was actively being mined on December 31st, 1975, which was the day before the state SMARA regulations became effective. Again, January 1st, 1976 is when the SMARA regulations as adopted by the state legislature became effective. One of the requirements to get an entitlement in terms of vested right status is that there is evidence that prior to that, the day before, the site was actively being mined. Again, per our records, we have not seen any evidence that that is the case, and that has not been provided to us. Second, regardless of any vesting right status, the county approved conditional use permit number 1 in 1989, which served as the mining entitlement for the project site. The adoption of the CP superseded any previous mining right status request, and it included the entirety of the project site. So again, that conditional use permit was not for a portion of this 280-acre site. It was approved for the entire project site. So again, that distinguishes it from other cases that we had before. The provisions and/or the requirements that were outlined within that mining entitlement were not followed, and subsequently the state determined that the site had been abandoned due to non-activity. Now again, at times, mines do alter their anticipated production, and to ensure the state does not consider a mine to be abandoned, there is an opportunity for a project applicant to submit what is called an interim management plan, or an IMP. That plan, if approved, would authorize the provisions by which that mine could operate during those times of low production. However, while we had discussions back in the time period in which this potentially could have occurred, no such IMP was ever approved for the old Dutch Cleanser project site. So I don't have anything in our records that specified that when the mine was having, I don't want to say difficulty to operate, but when the market didn't have the need for the materials or anything along those lines and the production was very low, the appropriate plans were not in place to ensure that the mine was not considered abandoned. And then finally, third, based on the history of the site, a new conditional use permit application was submitted and was being processed in accordance with our adopted zoning ordinance. However, no action was ever taken regarding that request due to potential environmental impacts that needed to be further addressed and analyzed in accordance with the Environmental Quality Act. That refers to the fact that in 2015, the commission referred the project back to staff and did not take action on the request to reestablish the mining entitlement. So during the processing of this request, which is the request to consider vested mining right status, notices were sent to all properties within 1,000 feet of the project site, and then a number of agencies and other interested persons who had been involved in this project throughout its history. At this time, we've received 7 comments. 5 of those comments we received are opposed to any mining activities commencing on site due to concerns regarding the adjacent Red Rock Canyon State Park and potential impacts to biological resources. So those 5 comments were provided to your commission this evening as a handout. And again, we received comments from the Desert Tortoise Preserve Committee, the comments from the Center for Biological Diversity, comments from Kern Audubon Society, comments from from Red Rock Canyon Association, and then we received a separate comment from a Miss Sherry Berbeckel, I believe is how you say her name. Again, opposed to the potential of establishing mining on this site again due to potential concerns. So at this time, it is the determination of the planning department that At this time, it is not the determination of the planning department that mining cannot or should never not occur on the project site. You know, clearly the site has had mining activities occur on it at some point in its past. But again, the question before us is not whether or not mining should commence. The question before us and before your commission today is whether or not this project site has an existing vested mining status. So it is the determination of the planning department that the site has not been actively mined for the past 14 years and that the project does not qualify for the vesting right status under existing state law. Any new mining activities that would occur on site need to be approved through the processing of a new conditional use permit, which would require the preparation of environmental impact report under the California Environmental Quality Act that would both analyze and identify potential mitigation to reduce potential impacts regarding any of the mining activities. If it is the determination of the project applicant to move forward, then the required conditional use permit would ultimately come back to your commission for consideration at a later date for either approval and/or denial. So with all that being said, it is the recommendation of staff today to deny the request for a determination of vested mining rights and require a conditional use permit and approved reclamation plan and adequate financial assurances for such reclamation plan approved by the Kern County Public Works Department, all prior to the commencement of any mining activities to occur on site. That completes staff's presentation. I'd be happy to answer any comments or questions your commission may have.
Thank you, Mr. Murphy. At this point, I believe, do we have a presentation this evening? I believe we do. From the applicant. Would the applicant like to come forward?
That's correct. Good evening. My name is Joe Matthewson. I'm a civil engineer and a mining engineer. Been in that business for about 30 years.
Mr. Matheson, I'm so sorry. Could you pull the microphone so that we could, thank you.
Sorry. Excuse me. Starting over. My name is Joe Matthewson. I'm the president of Matcon Corporation. I'm a civil engineer and a mining engineer. I've been a landowner and taxpayer in Kern County since 1983. I'm a retired military officer and Vietnam veteran. And we have owned the Old Dutch Cleanser mine since 1983. And my presentation will discuss a little bit of the history just to familiarize you with it, but also talk about and address the concerns that county staff has raised. Next slide, please. Next slide, please. We are located in 16 miles south of Ridgecrest, about 6 miles north of Cantil. We're the largest holder of property inside the Red Rock Canyon State Park. When we first acquired the mine, this was all Bureau of Land Management land. We also have a right-of-way easement from the county road, Red Rock Inyo Kern Road, into our mine in perpetuity. And we're the largest privately, as I said, privately owned piece within the state park. State park has always had an interest in this property, and we have tried a number of times to try to work with state parks, and we'll get into it a little later as to what those efforts look like. Next slide, please. What is the Old Dutch Cleanser mine? It's a very historic mine, early part of Kern County, history on mining activities in this county. It's one of only 2 deposits like it in the United States, the other one being in Kansas. It contains 3 products that are very mineable. One is called seismatite or pumicite. It's a natural pozzolan. The second one is a calcium bentonite clay, which is used in, or montmorillonite clay, which is used in landfill liners and caps, and in fact was used at your McFarland-Delano landfill closure. And also limestone construction aggregates for base rock and other construction projects. Next slide, please. As I said, it's a really part of the history. If some of you may remember or had parents or grandparents that used the Old Dutch Cleanser product back in the day, it was mined by the Cudahy Packing Company up until about 1948, at which time it was purchased by Purex Corporation, which owned and operated that mine for some years. It continued to operate it up until we acquired it in 1986. Well, actually, we acquired it in 83. And county has acknowledged that they don't have any records that say there was no mining that went on. I have none either, because the people that are involved in that transaction have all retired or have passed away. I have no way. In fact, I think Purex may not even be Purex anymore as an organization, so to recover those records would be virtually impossible. But I can assure you they held onto that property for a reason, because they felt that they had marketable seismatite pumice in it, and they were waiting for the market to turn around to be able to put it back into operation. Next slide, please. As pointed out, there's 2 pits, open pits. One is called the pumice pit, which is where the seismatite pumice is mined from. The other one is calcium bentonite clay pit, which is strictly a deposit that sits on top of the pumice. And then limestone is a cap rock that sits on top of both of those deposits. So there's 3 deposits at that location, very rare in this state. Next deposit, or next slide, please. The original mining was done underground by hand, and it was a dirty, nasty business. They would go down to LA and pick up the drunks off the street and bring them up and put them to work for 2 weeks and then cut them loose again. And they would mine this by hand in blocks and chunks, send it in a big a sled down to the bottom of Last Chance Canyon, taken out to the bottom of Last Chance Canyon to Saltdale, where they loaded it into railroad cars, shipped it back to Chicago, where they packaged it up and sold it all over the United States. Next slide, please. This is what the pit looks like today. This is the open pit seismotite strata. It's a pure white, fine-grained, powdery material, volcanic ash, that some believe was deposited there with explosions from Mount Whitney. Next slide, please. This is what the calcium bentonite clay looks like, and it's basically it's a clay product that's dried, crushed, and screened, and used in various applications, from animal feeds to organic farmers here in Kern County use it for pesticide applications, and also used for landfill caps, ponds, and lagoons, reservoirs. Next slide, please. Talk about the vesting eligibility. Next slide, please. County gave you an overview on what vesting is, but it is a property right, and it is a legal non-conforming use of the land, and our mine fits in that category and has since its inception. Next slide, please. It's the use of the land, not the ownership, that has to do with vesting, and the vesting runs with the land. So that is a major item for discussion, but that's why we're here tonight, is that we think that we were vested back when Cudahy Packing Company had it, when Purex Corporation had it, and we subsequently obtained it. And had we known back in '83 that the vesting was even an option to us, we would have definitely gone after those rights at that time, but we listened to county at that time on what our procedures were doing, what needed to do in order to put the mine into operation. And at that time, SMARA was in operation, or it was enacted. And so we went ahead and went through the conditional use permit process to satisfy that. Next slide, please. Again, as county or staff had told you, the original conditional use permit covered the entire mining property, and the intent to mine the entire tract has always been in place and has never been in question as far as we, the owner and operators, have been. Next slide, please. This is where we are hanging our hat tonight on vesting, is that no person who has obtained a vested right to conduct mining operations prior to September 1972 shall be required to secure mining approval for such mining operation as long as the vested right continues and as long as no substantial changes are made. In our case, the mining has continued, although intermittently over all these years. No changes have been made. The footprint is the same. The deposits are the same. The roadways are the same. There is no difference in what we were doing other than the manner in which we mine, instead of underground, above open pit, as opposed to, that's the only difference in operations. Next slide, please. What makes the vested right determination? Well, that's actually changed. It was the State Bureau of Mining and Geology Board until the law changed and it gave the rights back to you, the county. So you are now the lead agency for making that decision on vesting. And there really is not a lot of guidance on how you form that approval or disapproval, and whether or not conditional use permits are even needed, much less environmental impact statements are even needed to make a vesting determination. Basically, is the mine a mine? Has it been mined? Is there a history on the mine? Are there valuable mineral resources there still to be mined? Has the operator who owns and operated that mine done so? Those are all things for consideration on the vesting decision. Next slide, please. This is how we feel that we qualify and how we're different. In 1986, we were unaware we even had the mining right. I think it existed at the time we purchased it from Purex. But in acting in good faith with Kern County, we went to the county and said, hey, how do we do this legally? We want to do the thing right. And we went through, they told us at that time that our only option was to go through the SMARA permitting process, which we did. We spent 3 years going through the SMARA permitting process, and were awarded Conditional Use Permit 1, Map 113. And following permitting, we actively operated that mine for 22 years. ourselves, producing both pumice and bentonite products. Next slide, please. When SB 108 came in 2011, that created a problem for us because of a low production that we had at that time. The mine was declared abandoned by Office of Mine Reclamation because we didn't meet the production requirements. And we had a 1 year that was highly, with the McFarland Delano job, for example, we produced 15,000 tons of bentonite for that job. And the subsequent years after that, we fell below the cutoff. And so the state OMR declared us to be an abandoned mine. So it was not our fault. That particular bill, SB 108, did not take into account mines that were specialty mines that had ups and downs in the market that were dependent upon the demands of the particular product, and they was based basically on primarily rock quarries and aggregate producers, not for small miners like us. Next slide, please. So again, since we were declared abandoned, we decided to try to go back to the county, and we acted in good faith once again. Went to planning for guidance, and they said, all right, you got to go refile and redo the SMARA permit all over again. So we did. We spent the next 3 years going back and forth, redoing the studies, redoing the surveys that we did the first time. And again, the first time around, we hired the geologists, we hired the biologists, we hired the environmentalists, we hired the cultural research people. We went through the entire SMARA process the first time around and got our first conditional use permit. Now we had to go back and do it a second time, which we have done. Went all the way through that permit process, turned in the packages. It was deemed complete by the county, and they recommended at that time a negative declaration, and they elected not to go forward with it. I don't know that the Planning Commission had any part in it. The decision was made by staff to refer it back to itself and not go forward with the hearing because of comments received and their concern about several of the entities that had a problem with reopening the mine. And so as a result of that, no mining has been done since then because we did not have a permit, and we were trying to resolve the issues with the permit outside of the requirement to go get an environmental impact report. Next slide, please. This is why we feel we qualify for vesting. This property has only been a mine since it started in 1923. It is and always will be a mine property because it's really suited for nothing else. All the mine owners that have had this thing from start to finish have all indicated a intent to mine, so it's never been a question. It's only one of two deposits in the United States like it, and both have ongoing and continued demand for the mineral resources on this property. Next slide, please. The mineral resources and the mine operations haven't changed since 1923, so vesting won't increase it, change it, or modify it in any way. We're still modifying, just mining the same footprint that has always been there. We still contain lots of volume of product there to remove. Next slide, please. The mine holds a perpetuity, the legal rights to the same access road that existed since 1923 under contract with BLM, so there won't be any new roads cut. It's be the same exact operation we've had since we got our first SMARA permit. And while not needed to vest it, the mine was fully SMARA permitted in '89, even though it probably wasn't required at that time. Had we known about vesting rights and vesting how it should have operated at that time, had we had the right documentation and knowledge. Next slide, please. So in cooperation with county staff, a second, and we consider unnecessary SMARA permit was reapplied for in 2019, and went as a result of that SB 108 determination. And again, the county at that time recommended a negative declaration, and we're ready to move forward with it, but basically backed out because of some concerns that were raised by concerned people that had raised objections at that time. And lastly, it really meets, our mine really meets the legal requirements for a vesting determination. It's a two-pronged test in the regulations that creates that. Next slide, please. There's a timeline. The mine must have been in operation before 1976, which it was. and the landowner continues to mining the deposits, which we have, and there can be multiple mine owners between 1976 and today with the intent to mine, and that's not changed. Next slide, please. The preponderance of evidence for vesting is really the claimant, the burden of proof is on me, but the lead agency shall determine whether the claimant, by preponderance of the evidence, is demonstrated through testimony, exhibits, and enough evidence to support the claim, we have vested rights. The amount of evidence is basically just enough evidence to make it more than likely that the fact that the claimant seeks to prove is true. So that's what I am relying on, that you will hear my request tonight. Next slide. What constitutes relevant evidence? It's basically written or oral or evidentiary statements and evidence of mining activity that commenced before 1976, which staff agrees with. Next slide, please. There's several contributing factors to this whole thing. The biggest issue that the county has faced is the objection from Red Rock Canyon State Park and its stakeholders, primarily the Friends of Red Rock Canyon State Park, the Desert Tortoise Preserve people, and Center for Environmental Diversity, and all these folks. And we've worked to be able to mitigate some of that, and we're all currently working with California Fish and Wildlife to donate 150 acres of our 280-acre property to them as mitigation land for desert tortoise, Mojave ground squirrel, and burrowing owl. And this will become a part of Red Rock Canyon as protected habitat. And again, it's a donation at no cost to them. So this is to satisfy mitigation requirements for another mine as well as this one. But we've been working on this for 4 years, and having two agencies like Fish and Wildlife and state parks get together on anything is a real challenge. Just to get a simple MOU between them has taken over 2 years, and we're hoping to get this thing resolved in the next 6 to 8 months, according to my latest conversation with state parks. But aside from that, state parks, we have a very good relationship with state parks, but these folks that are friends of state park, friends of Red Rock Canyon, the Desert Tortoise folks, they all have their own little agendas, and as a result of that, it complicates the issue. Otherwise, there has been no change since the time we've had this mine in biological resources, in cultural resources, impacts to the environment. Nothing has changed over both SMARA attempts to permit this project. Next slide, please. So what we're really asking you for tonight is a vesting determination that will recognize our right to continue to operate this mine. Now, staff tells me that we have some people that are have written objection letters. I read them. They're really not much of anything other than we don't want to see dust and noise. But however, they take exception to the fact that we're going to try to reopen the mine. We have tried very hard to mitigate all those issues, particularly our dust and noise, because where the mine is located is in a little valley, and it's really, you can't see it, you can't hear it, and the dust is contained, whatever little there is, because we're under the PM10 requirements from the Mojave Air Quality Agency. So once again, those objections do not fly. Next slide, please. The nice part for vesting, as far as our reason for going after it, is it will allow our operation to continue without having to undergo another expensive, lengthy SMARA permit application review. The long process will only confirm what we already proved to county twice, and to go through it again simply to satisfy the few concerned environmentalists is to us a large expense that is going to prove absolutely nothing more than what's already been proven, except cost us a tremendous amount of money to be able to satisfy these folks. And we don't think not only is it not fair, it's not a requirement that should be applied to us under these circumstances. Next slide, please. You are the ones with the authority to make this little mine work of ours, and your approval of vested status is therefore really requested. And there's several things I wanted to rebut on, which is what the handout that I gave you is. It's not up on the slide. Wasn't able to adjust these slides at the time we made the presentation, start of it. But if you'll go back to the last 4 pages of that, I've already covered the first ones, but the last 4 pages where it says current staff conclusions are incorrect. Staff indicates that there's not been a reclamation plan in place, when indeed there's been 2 reclamation plans promoted. Staff has said that there's not a financial assurance posted, and that's incorrect. We have an $81,000 reclamation assurance posted, cash post on file. The fact that there's no ability to research or to know or just to disprove that there wasn't any mining before 1976. Staff has no ability to prove that, nor do disprove it, nor do we have ability to prove it. So it ought to be a moot issue, because there was a mine there. It was owned by mining companies, and they didn't hold that just for the fun of it. Again, the Old Dutch Cleanser mine property has been subject to 2 environmental, biological, and cultural assessments, and nothing has changed. No conditions have changed. We have a permanent easement, as I've said. We've had a conditional use permit and a new recommended mitigated negative declaration from county staff. So we've gone through this thing twice. We've always actively mined and intended to mine the deposits, but have only been stopped because of the problems regarding the permit. And we've diligently not mined it for the last few years because we were unable to, because we didn't have or feel that we had a permit that allowed us to do that, and we didn't want to get crosswise with the county and violate anything that they had told us not to do. And lastly, the part that I think is most concerning to us, as well as the EIR requirement that's being imposed on us, that we made every effort to work with the Red Rock Canyon State Park people, which are the primary objectors, I guess you would call them. We've tried on 2 different occasions to sell the entire property to the Red Rock Canyon State Park. In fact, we've got very close to even doing that until they ran out of money. The funding got pulled by the governor, or it was slated someplace else. And so we went through the Conservation Fund, who tied up with the Sierra Club and got the funds approved to be able to buy the property and turn it into the state park. But it fell apart at the last minute because the funds were pulled. So it's not from lack of our trying to not work with these people. If they object to what we were trying to do, then they need to reach into their pockets and try to buy the property, and they can have it in the state park. Aside from that, we need to put this property back to work. We have a great demand for the mineral products there. Right now, there's a shortage of fly ash in California and in the western U.S. because of the shutdown of the coal-fired plants. Our pumicite pozzolan is a natural replacement for that. We have people that have tested it and played with it and want to buy it as soon as we can put the mine back in operation. So it's a valuable resource for the county, and it's a valuable property to us. And we feel that we've gone more than out of our way to try to comply with county regulations, and we're just asking for consideration by your board to be able to approve our vesting and let us move forward with whatever we have to do to put the mine back into operation. I thank you very much for your time. I'm sorry it got a little long-winded, but I feel very strongly about this, and hopefully you can tell that in my presentation. Thank you.
Thank you, sir. At this point, do we have anybody else to speak about this project?
Do you have any questions? I guess
That would be the next thing after that. If not, then I ask the members of the board, do you have any questions for our applicant?
None?
I have questions, but I don't know if it'll be addressed to you right now, so if you might hang tight in the front row.
Yeah,
that
maybe
might
good
be
to close the
helpful.
public portion, then we could call them back up if we have some questions.
Okay. Very well, we'll close the public portion. This time we'll discuss. Open for discussion.
Commissioner McGiffey, I have a couple of questions
Yes, Mr.
for
Judge.
staff. Mr. Murphy, just so I understand this as well too, is Number one, I appreciate the presentation given by the applicant here. From my understanding is that the CUP that was approved on this site, there was an enforcement in place due to the financial assurance being expired and or not in place any longer, and that is why the initial CUP became, action was required to, on that. Is that my understanding?
Commissioner, or Chairman, Commissioner Judge through the chair, I think that was part of it. It also had to do with financial assurances, the lack of mining activity that occurred on the particular site at the time. Again, as the comments were made, in order for a project to be active, you have to continue to be using that particular site. So again, while there are opportunities to, especially when it comes to mines or other type of projects like this where the production varies, it was determined that the reported production was so low that no activity was occurring on site. And so financial assurances was part of it. But the other concern was that there was no activity that was occurring, by which fact then the site needed to be reclaimed and it was considered abandoned. So that was also part of the issue, is that based on information being reported to the state as to the activity that is being done at the site, there was not enough to justify that the site was not abandoned under the legal determination. So the county then entered into the process of going through the enforcement actions to, one, to get financial assurances, that was part of it, but then two, when inactivity occurred on the site, to try to get the applicant to help us establish, is it abandoned, is it not? And it was determined that the site was abandoned. So again, this was a number of years ago. I would say that the intent was for staff to actually go forward and reclaim the mine, cash in the financial assurances and have the mine reclaimed. But the project applicant said, no, I do want to continue to mine on the site. I will re-permit this, and I would like to go through that particular process. So that's when the second conditional use permit was being processed. And I do appreciate the presentation given here, and I do have that understanding, and I recognize the attempts to get the site reclaimed or to reestablish its mining entitlement, but many of the comments that were brought up have to do with the California Environmental Quality Act, and staff attempted to see if a mitigated neg deck was the appropriate avenue. Just like any applicant that comes in on any particular project, every project that requires a decision by your commissioner or the Board of Supervisors is subject to the Environmental Quality Act. And this particular site, unfortunately, has unique characteristics given its surrounding uses. And at the time, it was not believed that the document that was prepared adequately addressed the concerns that were raised, that a negative declaration was the appropriate environmental analysis that needed, and therefore the recommendation and ultimately the Planning Commission's decision was to refer the project back to staff for preparation of the environmental impact report. Again, I do acknowledge that throughout this history, there has been activity that has occurred on the site from a mining perspective, but it didn't continue, and it was sporadic, and even the applicants' even comments here, they've attempted to try to sell the mine to Red Rock Canyon State Park. Clearly, there has been an ongoing attempt to try to address this concern, and based on all of the history, there's just no way that staff can say that a project that we approved with a conditional use permit was operating, fell out of compliance with that exacting same condition, tried to re-permit a new conditional use permit, can now all of a sudden go back and say that it qualifies for a vesting right status given that history that we've come through and the inactivity, the sporadic activity of mining that has occurred over the site.
Thank you, Mr. Murphy. And that's what I'm trying to determine, understand, is that process. So, and I understand the request of the applicant today, but at the point being, there was a CUP that was approved on this site. The site in 2009 looks like it fell out of compliance. They were also given 30 days to try reinforcing that. It went over to 90 days, up to a year. So the CUP, what did it become inactive and, in a sense, needed to be reapplied for, since it was an abandoned CUP, in the sense it was no longer an active CUP, correct?
Correct.
Okay. And that was, I want my clarification on that. And the applicant was aware that this was pulled because due to the reappliance of CUP, it did have to go through the whole review process again, the natural process, and at that time, the neg deck was brought up, and the EIR was brought up at that time, and nothing at that point was ever brought back to this commission or to the staff to address the EIR concern or the continuance of the project from that time? after that
Commissioner Judge, through the
2015?
chair, that is correct. After the item was referred back to staff, there had been a number of back and forth with the project applicant and staff as to, okay, what is the process? How would this work? Where would we go through? But nothing has been brought back forward. No additional environmental analysis has been done or anything along those lines since the time of 2015 when the item was referred back to staff, other than continual discussion as to the requirements to prepare the environmental impact report and then working to try to get that deemed complete.
And so just to wrap it up, so now we're at the point of now saying that's where the request for the vesting is coming in and basically saying, trying to bypass the EIR or any requirements that was put back originally. So I just wanted to clarify that and have understanding of the process. So thank you for giving that to me.
Can I address that?
I not yet, sir. I think if you were called up, we'd allow to bring that up, I think. So thank you.
Thank you, Commissioner Judge. Are there anyone else who have discussion about this?
Okay, I think I don't really have any questions. It seems fairly cut and dry to me that the whole vested rights piece kind of hinges upon that continual operation. And so I think everything that happened after that, you end up kind of getting just caught in being a victim of circumstance. You're trying to do the right thing. The county, more than anything, was trying to guide you down a path that I think was the correct one, because the NEGDAC or mitigated NEGDAC is just so easy to get to win out over a fair argument standard. You know, the people say, look, here's this preponderance of evidence about biology all over the place. You have people that are going to, I know these players, Sierra Club, Center for Biological Diversity, they just hang out and wait to sue you for things like this. And so you would be at that point, I think, forced into an EIR anyway. And so I think what the county was trying to do was say, this is a more predictable path for you to go through an EIR. You know, it gives the public a chance to say what they need to say, and it gives you a chance to prove that you, which I think you can do, that prove that you can operate a mine in that area safely. So I'm inclined to urge you to go down that same path again. I know it sucks for in terms of timing, but it is a more predictable path. You could get the vested rights tonight, perhaps. You would get sued, and you would end up doing an EIR anyway, I believe, in order to be able to continue the operations there. So just a matter of opinion more than anything else. I think all your points made perfect sense to me. So I think, yeah, more a comment than a question.
Thank you. Are there any other?
I have a few questions, and I'll apologize ahead of time because they might seem out of order and random. Mr. Murphy, can the applicant provide financial assurances aside from the CUP, or would that not even be necessary?
Commissioner Skidmore through the chair. So again, as I previous discussion, there's a three-pronged thing that have to be in place to allow for mining to occur. An entitlement, an existing reclamation plan, and financial assurances. Yes, I mean, let me kind of go through it this way. The reclamation plan and the mining activities, while they're separate things, you know, you have the entitlement to mine, the reclamation plan is based on how those operations are occurring and what has to be reclaimed. That's what that cost value, how you qualify what those assurances are and things along those lines. So normally it all comes as one complete package when we go through. In this particular case, while I think the county does have a financial assurance, it's not under the project applicant's name. It's under previous owners who have actually come to the county and requested to have that financial assurance back. So yes, at the very least, one of the first things that would happen is we would have to get financial assurances in place that were applicable to the reclamation plan that's in place and the mining activities as it is. The other question that I can't answer indefinitely 100% for sure is, yes, when the project was approved under conditional use permit number 1 back in '89, a reclamation plan was in place. How the operations would continue, I can't be sure that even if a vested rights status was determined tonight, that existing reclamation plan is still appropriate and wouldn't have to be modified. And if it had to be modified, that's still subject to the California Environmental Quality Act in some form or another. And so even if a vested rights was determined, I can't definitively say today that the existing reclamation plan that's in place, that was approved in '89, that we don't have the appropriate financial assurances by the applicant today, wouldn't have to be modified or looked at or reviewed at some point to make sure that the way that the operation is operating matches how the reclamation plan says that it had to operate back in 1989 and everything along those lines. I mean, that is a question too in terms of, you know, while a lot of comments where there have been no changes from a project boundary site, that is true. But over the history, there have been changes in how the mining occurs, what type of machinery, everything along those lines. And technically the reclamation plan has to match the type of mining operations. So if you change your mining operations, that could require a change in the reclamation plan too, just depending on how you're mining and how you're operating, anything along those lines. So I know that was a long-winded answer. The short answer is yes. I mean, clearly if there was a way financial assurances could be provided, it can kind of cover, there is still a question on whether the existing reclamation plan from 1989 as is would not require any changes in and of itself as it is.
Is there a way for the applicant to kind of pick up where they left off from 2019?
You mean from 2015 in terms of the
Yes.
environmental analysis and everything along those lines?
Correct.
Yes, so again, studies were prepared when it came to the environmental document. You know, clearly that has been 6-7 years, so the studies would have to be updated. You know, a lot of the studies that were in place, especially things that are not changing, can be used again. But again, the difference between a neg deck and an EIR, one, an environmental impact report allows you to have significant impacts and a determination by an elected body that even though there are going to be significant impacts, the project should be approved despite those, and we've mitigated everything that we can. With a negative declaration, there is no ability to say that there are going to be significant impacts, but we should approve the project anyway. The negative declaration specifically says there are no significant impacts. And again, based on the information that was submitted in 2015, the county was not comfortable being able to make that statement and recommend that your commission or the Board of Supervisors ultimately be able to definitively say that there would not be any significant impacts. So that's why, based on the public process that occurred under that time, it was determined that additional analysis was required under CEQA, both to analyze the site, but then also for the appropriate findings that would need to be made to ensure that the mining activities could occur and to address any of those particular impacts.
What is the vulnerability of the applicant to, I guess, open up the CEQA lawsuit potential? Like, what does that look like for the applicant to proceed as how the route he would like to go?
Commissioner Skidmore, I don't know if I can appropriately answer that question. I mean, that's a level of varying, you know, risk and things along those lines. I mean, I can tell you that from the county's review, there is no existing mining entitlement right now that we believe they have in place. So if any activity occurs on site, I would say that there are potential risks associated with what people may bring forward in terms of, hey, you didn't have the right to mine and you're going through those activities. In terms of the process itself, it's no different than any project that we go through where, you know, some projects we thought that a neg deck would work, some projects we thought an exemption would work, and then when you go through the public hearing process, it determines that it wasn't appropriate, and so, you know, then the next step is ultimately required.
Is there, and maybe Mr. Hall, this might be a question for you, is there like a legal definition for activity on a site like this?
No, it'd be very difficult to find what activity would be. Evident from the record here, there was an activity for a period of time. Was that enough to cause a problem? It seems like it is. And let's talk about two things related to that. The other thing that I'm hearing here that is jumping out at me is the request for a vested right. Well, CEQA, to answer your previous question, I'm concerned about CEQA on vested property right, because anytime you're making a determination at this board level that is not ministerial is subject to CEQA. And we have a situation here where we don't have a particular easy formula to say, check the box, ministerial things happened, therefore this is a vested right. You know, that's ministerial is, check the box. And even in the applicant's response to what we should be looking at here, it's not a check the box to determine I'm vested. I think there is something to be said about the 1 year, having 1 year jump versus annual. I think you could probably find some case law or in fact make case law, because it probably hasn't occurred that much, that a 1 year jump doesn't affect everything, but we haven't seen anything in this record which shows me that there was continual activity based on even a more annualized record. So that jumps out at me on activity. I mean, there just aren't a lot of cases on this stuff. But the vesting really jumps out at me to say that, to try to say that it's ministerial and not subject to CEQA right now would concern me. And I'm sure there's no case law on this that we can point to, because this sort of thing doesn't happen. But based on the record before us and the concerns that staff had about going to an EIR before, I think those are very valid. And I don't think going through the vested track is going to really get you around the fact that somebody will then come in and say, this wasn't ministerial, this was a discretionary act that required CEQA. So, that's all I have.
Thank you, that's all I have.
I had a question for Mr. Murphy or Mr. Hall, and just looking at this request, it does seem to me they're asking for a request for a vested right, and by what I read here, it does appear that this was maybe overlooked or maybe wasn't considered in the past, and doesn't mean we shouldn't consider it now, even though it was overlooked, or because it doesn't seem like the other actions overrule a vested right. Whether or not CEQA comes after the fact, I'm not sure if we don't have a situation where a vested right should have been determined to begin with, and what follows after that, I'm not sure, but I believe the request is for a vested right determination, and it does seem to me there is a vested right, given what's happened here in the past, that we might want to correct. Is there something there that I'm missing? Because that's what it seems like it's before us.
Well, I think there's two things I would say to that. First, I'm not sure at this level, on the facts in front of us, that you can make a ministerial decision on vested, which means your discretionary act, you're looking at CEQA. Aside from that, I think what would happen, frankly, and again, there's not going to be a lot of case law on this sort of stuff, because this kind of thing doesn't happen, or it happens so rarely, nobody's going to have the case law. But you're going to have a situation where the court is going to say, well, you chose a path, you have to stick with your path. You can't decide at the end of the day your path isn't the path you wanted. So should they maybe have done vested 30 years ago? Maybe. Maybe they should have done vested even before that, but they chose a path. And whether or not that path was the appropriate path at the time, they chose the path, and my suspicion would be a court would say, you chose your destiny.
Chairman, gives me the other thing I would just offer, two items here is one, again, based on the evidence of the record, when the mining was mining occurring on December 31st, 1975? So in 86, when they processed this in the first place, I don't think we'd be able to make the determination then. If I don't have the information now, I'm sure back in 86, they didn't have the determination, which is why they said you needed to go through a conditional use permit, because it didn't qualify for the vesting before. And again, what makes, just as again, I appreciate your commission struggling with this, but what makes this case unique than every other one of these, again, is the format that this site had a conditional use permit that covered the entire project site. You know, previously, let's just talk so you have the context here. Most of the vesting rights happened because clearly, let's say 30 years ago, 50 years ago, 100 years ago, when you had a mine site, you know, it could be a very large area, but they only had an approved reclamation plan for 20 acres because clearly no one is ever mining 100 acres all at one time. You mine in a spot and you kind of move as you go through deposit. So when this was envisioned, what this vested rights really was about was, I have 100 acres. I've always had 100 acres. I've only mined 15 of those acres continually since 1920, 1930, whatever it is. They come into the county, you know, I only have a reclamation plan that covers that 15 acres because that's all I was mining. And so the question was, well, if I've always owned 100, clearly I have deposits next door. At some point in the future, I was going to make, that is what the vesting rights really was always all about and how that process was being done. In this particular case, we don't have that situation, you know, and that's where when we processed a conditional use permit, that was then the laws by which this site would operate. Conditions were adopted, requirements were in place, how the mining had to occur have been in place. All that was done as part of that conditional use permit. So to answer your question, the situation in this site is so different than any other vested rights that we have come forward, which again, I appreciate that's what makes it complicated, but it doesn't counter the fact that there was a permitted site. They went through a process to get mining rights to the site. For whatever reasons, and I'm not saying it is this applicant, but the property owners over the course of that time lost the mining entitlement based on the actions of applying with our conditional use permit. So much so that the county felt that they needed to go through that conditional use permit again, which at that time the applicant did and didn't like the decision at the hearing, which is what brought us back to today. So again, it's a very unique type of situation that is before you. And again, I do appreciate Mr. Matheson's passion about this and his desire to utilize the site, and your commission struggled with this consideration. But again, we're just looking at the information before us, and it's difficult for us to be able to say that it qualifies under the state laws of what vested rights means.
Thank you, Mr. Murphy. I'm just reading it since 1972, and it seemed like clearly we had that, and whether or not all the other things happened in correct order, I think the right thing is to follow the law here, and the law says the vested right determination, and doesn't say we can't make one. All it says is this is what happens here, and whether it's retroactive or not, I mean, it does seem to me that we have every authority to do that because we do know it's mined before that. We do have evidence of that before 1972, and that's which is what I'm reading here in this ordinance or this law. So, you know, to follow the law, even whatever happened after the fact, I'm just saying, if our request is here to determine if it's a vested mining right, well, to me, it's pretty obvious there is a vested mining right based on this way this is written. I don't know everything after that I'm not sure about, but it does seem to me it does have a vested right, and whatever follows from that, we're kind of correcting the record here, I would think.
So, Chairman McGiffney, the one part, and again, if it is your desires commission, you can always recommend a continuance so staff can further go through. I don't think the provision is, it was mined sometime before 1972. I mean, if it was mined in 1880, but then stopped mining in 1990, and then it continued and left vacant for 40 or 50 years up until 1972, does that mean it was vested rights? I mean, the question was, when the law was enacted, was it an active mine at the time that the law was enacted? So I don't think the question is simply, was it previously mined before that date? Was it mined, and was it actively being mined at that time the legislation was enacted and began to move forward? And that's where we don't have specific information that says, oh yeah, in 1972 through 1975, we produced X, Y, Z, and this is the materials that were done, and we can make that case. We don't know when that mining occurred sometime between 47 and 76 is what one of the concerns we have from that perspective is.
Okay. And I guess my question would be, when we're reviewing this and trying to make the determination, I mean, what exactly are we looking at? Was the applicant just want to request for determination of vested mining rights? And then if once that happens, we go to the next step, we have to go back and get a CUP? Or are we just, in the entirety of this project, what are we looking for? What is the applicant really looking for? Just the one thing, or are we looking for the whole thing, I guess?
Chairman McGiffney, it is my impression that it is the applicant's belief that if your commission says that you have vested mining right status, that he would post his whatever financial assurance he needed and go out there and start mining tomorrow. I mean, that's an exaggeration. I don't necessarily mean tomorrow, but that there were no other actions needed, that he has the legal right to go out and mine. And staff is concerned that, one, I don't necessarily think that's the case, because his existing reclamation plan, I'm not sure covers the activity he's doing now. That may need to be updated, which triggers CEQA, and I'm not sure that we could definitively say today that the existing reclamation plan in place is adequate to have him mine as it is. But I believe that the applicant is under the impression, and they would operate in such a manner that they would go out and believe that they have the right to commence activities as soon as that financial assurance is in place. And then the question comes in, so I have a CUP that was null and void, but yet now they do or do not have to meet any of the provisions of what that CUP said or anything along those lines. But again, that is my belief in terms of the applicant's intent regarding this request.
So I guess I'm struggling with, if we made a determination of vested mining rights, we don't know what follows next. We haven't looked into what happens. Hey, you know what, this looks, it should be invested. We made a mistake, or somebody made a mistake. But after that, what's the next step? And you said there's no case law or other things to look at. I'm just concerned that, based on what I see here, it's probably vested, more likely than not. However, what follows, what's really supposed to follow after that, based upon all the other stuff, we need to make a determination, I would think, wouldn't we?
Well, again, Chairman McGiffney, to be allowed legally to mine, you have to have, one, a minor entitlement through either an approved CUP or vested mining rights, two, an existing reclamation plan that has been approved and in place, and appropriate financial assurances.
Right, so I'm saying here, we may or may not have an approved reclamation plan and financial assurances, but we seem to have, in my reading what I'm seeing here, a vested mining right, although we may not have the other things. That's what as I look at this, that's what it seems to be to me. Maybe I'm mistaken, that's why I'm asking these questions here. I'm not sure if we pass through this or not.
Chairman, I hear you focusing on the first prong of the test, actions before 76. Clearly, this was a mine before 76. I haven't seen anything in the record that we've seen so far that shows there was an intent to mine after 76. There are many years that this mine does not seem to be operative. There's been discussions about selling the land to Red Rock. There's many things that bring in this second prong that are problematic. So if you're considering giving it vested status, I would ask that you seek a continuance so that at least that provision of this test can be further supported, because you're going to have to live with the record here today, and I haven't seen anything in the record today that really meets that second prong. Not a preponderance of the evidence anyway. Maybe that exists, not saying it doesn't, but because of the way this hearing happens, this is a quasi-judicial hearing, you have to live in the record that is in this hearing, and right now I don't see the evidence to meet the second prong that your commission could rely on if you were challenged.
Right, so if we did have a continuance to determine, the second prong, we could go back and make this, determination. Because it does bother me that there is a vested determination and there's law here and it says, yes, you should, maybe. But if, like you said, there's not a second part, then maybe that would, nullify that. But I'm still looking at this like, well, maybe there was a mistake made and needs to go back and be reviewed before we move forward on everything else. That's the way I see this right now. But I could be, I'm just trying to make sure that determination here based upon all the factors.
And I appreciate that. My point is that the applicant has to bring that evidence forward to meet that second prong, and they should be focusing on that second prong right now, because as I was saying earlier, I think a court, if they see this, is going to say, you chose your destiny.
Sure.
At some point in time, you should have been looking at whether or not you could have met that second prong.
Yeah,
And that is concerning right now under the record we have.
okay. Any more discussion from the board here? Commissioner Judge.
Can the applicant address this discussion?
Thank you. And thank you, Commissioner McGiffney. Excuse me. And just to kind of update what Chairman McGiffey, speaking of timelines, is it my understanding that the determination has been made that since 2008, there has been no mining on this site for the last 13 to 14 years?
Commissioner, Judge to the Chair. Yes, so any mine operator is required to report to the state the mining production that we have gone through. To my understanding, it has been reported as zero or minimal from 2009 until present. There has been no mining activities that occurred on site from that time.
Okay. So and again, this is my question maybe to Mr. Hall is, no matter what the vesting could have been earlier, it is determined currently that there is no mining happening on that site, and that within itself is not a continuance of mining on it's been years. So would that kind of qualify it not to being in production and continuing mining? And I'm just trying to understand, to clarify what Chairman McGiffey was speaking of.
Commissioner, you were heading down the exact path that concerned me. I don't know that we could meet the intent prong. And maybe we can with further evidence, and thus a continuance could be helpful for that. But we need further evidence, not just testimony. We need something specific that you can point to and put in this record if we're going to head down a vested path. Because again, the court's going to be, you chose a destiny, why did you head down this path if you could have already met these? And I understand mistake happens, and I understand, not denying that it might have been the path of easier resistance, and that's why they went that way, and it turned out to not be the best path in the end. But that concerns me, and then I must say we really should be looking at the CEQA concern.
Yeah, and that's kind of where my concern comes in as well too, is I understand the applicant about the vesting right. He was not aware of it at that time, and years have passed, and don't get me wrong, as a developer myself, sometimes you look back and say, I should have done this. But I think us as a board, in previous history as well too, we don't allow someone to say, well, I didn't know what the law was or what the condition was, that's why I still operate the way I wanted to operate. That's not really a reason to be able to do something. If, in my view, they applied for a conditional use permit knowing that that is what they had to do to be operational, that CUP at some time and point got null and void, and they went back for reapplication. Again, knowing their destiny in that situation. I would like to call the applicant up, and I know I apologize, you wanted to speak. I'd love to have you give the opportunity to you what you wanted to say, but also the question I have is, going through this process, the question I have for you is, I understand your request for a vesting right. I'm having a hard time trying to justify that based upon the longevity of no mining the last 10 plus years, plus nothing that was provided today showing that this was an active mine during this passing of time. So my question to you is knowing that in the EIR or the process that was put before you back in 2015, is there a reason why you do not want to pursue that path to get the conditional use permit and make this mine active and have that right?
Well, let's go back. The reason it hasn't been mined is because of the problems with the permit. I have been unable to mine because the conditional use permit has been in abeyance, or the mine has been declared abandoned, and I've been spending this time trying to get it back permitted through the second permitting process. So the fact that there's no mining, and then on top of that, well, there hasn't been any mining, there has been some stockpiled material out there that we have been removing because it's stockpiled, it's already been previously mined, we're able to sell it, there is a market for it, and we have been taking that out over a period of time, but there has been no active mining of the site beyond that. So that all being said, the biggest reason there's been no mining out there is primarily because we didn't want to go against the county and create a problem for ourselves because of the situation on the permit. So that's why we went through the permitting process again in order to circumvent that and to be able to be in a position where we could be legally out there mining in accordance with county regulations. Now, getting back to the reclamation issue, again, we had a valid reclamation plan. There is reclamation financial assurance in place right now. The previous owners forfeited that because I ended up having to foreclose on that property, not once but twice, from these same owners. And that assurance is still there and could be and is active. If we have to replace that, that's fine. We can in fact do that, but no one has ever asked us to do that, and it's all been tied to this permitting process. So we've been playing with this permit issue for the last 10 years, not by choice, but because that's just kind of the way the situation has been, and we're trying to rectify that. We've got to the second mitigated negative declaration process, and the part that vesting will help us with that is that we're more than willing to move forward with that second permitting activity, but vesting will keep the environmentalists at bay. Vesting will keep the people that have a problem with continuing mining operations out there at bay, because it will be a vested mine. Now, to give you a little background, San Bernardino County just went through this with a mine that has not been operated for over 50 years. It was a mine, it was established, it was a quarry, a big quarry there in the Cajon Pass, limestone mine, and they hadn't done a thing on permitting, and they were able to bring that back without a permit through vesting. And even though the county ruled against it, didn't want to have it vested, the Planning Commission said, heck yes, give these guys vesting and let them go to work. So that was San Bernardino County. Now, they're a very miner-friendly county, but at the same time, they went against the recommendations of the staff and vested that operator, and he's now operating that quarry. So there is precedence for it, not just with in this particular case, but there is case law on it, or at least precedent, not necessarily law, but precedent on it as a ministerial decision. Now, from my perspective, we've got a conditional use permit. We had a reclamation plan that was approved. Our mining hasn't changed from that activity to the new activity. Same footprint, same everything. We just redid everything. Same study. We conducted new studies. Went through the whole process a second time from the first time, and we're ready to go before you all to get approval on our permit. And it was this fear of the Center for Environmental Diversity and the comments that were received that stops county from moving forward on that. Now, vesting would preclude that, and that would allow us to move forward under the new conditional use permit, permit number 8. We're more than willing to comply with all the terms and conditions. That's a CEQA compliant permit, because we've gone through it all. We're more than willing to comply with all that. We just want to get back into operation. And how the best way we can do that is through vesting, takes all that away from us, allow us to move forward with a mitigated negative deck and go back into operation.
I do have one question for you, and because the initial CUP expired and it became not compliant any longer. Any reason why that happened? Were you just not aware of the situation, or what? Can you explain that?
What happened with that one was that the SB 108 came in, and we fell below the production levels that they required. So they wanted us to do what they call a interim management plan. The county says we never received an interim management plan, but that's not true. We did turn in an interim management plan, and the county sat on it for 60 days, taking it beyond the cutoff, and then they wouldn't recognize it as having been a valid plan. So they wouldn't allow us to move forward with that. So that's when they declared it abandoned. So we moved forward with it. We submitted all the paperwork we needed, albeit it was towards the end of the deadline process, but we assumed the county would process that, take it with some sense of urgency, which they didn't. And as a result of that, we went past the deadline, and it was no longer recognized as a valid plan. So that's why.
Okay. Thank you.
Any other questions for our applicant?
I thank you very much for your consideration, and I think you've given it a lot of thought, and I appreciate your questions.
Thank you.
I just want to chime in real quick. I'm kind of in the same boat as Commissioner McGiffney on focusing on that second prong of the vesting mining rights. I see both sides, but I also think that these situations and the long history that goes into them make it outliers for what is normal business practice in some of the industries here in Kern County. And so, I also see that the engagement with the Office of Mine Reclamation could classify as intent to mine. And I just don't feel like I have enough information this evening to make a definitive vote on either or. I mean, I personally would like to see maybe us come back with more information about that second prong approach for the vested mining rights.
Anyone else? Comments?
I have a question for the applicant one more time, if you don't mind. So you can see the commissioners brought up a couple items here. Is the determination tonight, if this gets denied, you'd have to try to appeal yourself and go through the process. The question I have is brought up by both commissioners here, is if this was continued, are you willing to pursue the request to try getting the information to show that this was an active mine, have more documentation, or that information not even available to you? Because I don't want to waste your time or the staff's time as well if that's not something you even want to pursue. So I'd put that question out to you, if that's something you're interested in doing at all or not.
No, I am. I'm able to provide whatever information that you're looking for to the best of my ability. And again, we've got good documents, we've got bills of lading, we've got shipping documents, we've got things of those natures that we can provide over that period of time. It just depends on definitive what period of time we're talking about here, but exactly I can provide that information. I can't provide anything before 1976, but the fact that it was owned by the Purex Corporation, a large mining company, who had held that property for all those years and had actively taken samples and truckloads and out of there for test marketing over that period of time, there was mining going on. Do I have any documents for that? No, I don't. Do I know that it occurred? In my conversations with them at the time I purchased it, that was part of the discussion we had of their past activity and what they planned to do with it and how they were marketing it, because we were looking for marketing ideas ourselves. But short answer to your question is yes, we're happy to provide whatever information we can if it will assist in this decision.
Thank you.
Thank you.
I just will wrap up on my portion now, and I would say that, I see both points of it as well. Obviously this has been been mined for years prior. I just have to fall onto the side of that. No matter what happened, CUP was applied for and it was active, and a CUP got expired and they came back to apply again. So the applicant, at whatever time, knew that, I had to go through these processes and I had to have a CUP in place. And as we have done in past, to all activities we've done, and we give someone a CUP, they have to meet their conditions. And if the conditions aren't met, the CUP will come null and void, and we have to abide by that. And I agreed on the extent of, my concern would be, it would be hard for us to justify us approving vesting without getting determination of CEQA or issue on our board for that type of determination. I just want to put out that I feel that staff has made a good recommendation, and I'm comfortable on my part.
Anyone else? As we said here, I mean, there does seem to be a definite potential for vested right determination. Whether or not that gets to the CUP isn't maybe another question, but it does seem to me that there is some information needed to make that determination, because it could go either way at this point. I would say, based upon what's written here, yes, it would be vested. But again, with Mr. Hall brought up some points, we probably want to verify or see how much more we would need to justify the vested right, because there are some potential legal issues. Mr. Mathewson brought up the point about San Bernardino County. We should perhaps look at that as a precedent as well. Regarding the question of vesting, to me, it's definitely possible. And if that does become the case, then it does make some things easier beyond the CUP. To my thought, maybe if the applicant seems to agree here, that we might want to go ahead with a continuance to find out and get that information, so we could do a full evaluation on the vested right, because there is question in my mind that the vested right is very possible, and it would help the applicant move forward with the mine based upon the conditions shown here or the conditions needed to get the permit approved.
So, Mr. Murphy, will you help me craft a substantial motion? So my motion is framing around Mr. McGiffney's comments to request for staff to work with the applicant to determine vested mining rights at a later date. Do we need to identify an actual date?
Commissioner Skidmore, through the chair. So I am absolutely comfortable if your commission desires to recommend a continuance or anything along those lines. Staff does not believe this project qualifies for vested mining rights. We are happy to evaluate the law, bring back additional information to your commission regarding, okay, in order to qualify, this is what it means, and I am absolutely happy to make sure that we go through that. But the one part I just, and Mr. Matheson is welcome to provide us whatever information he believes is necessary to help prove and substantiate that he believes he has a vested rights, and we'll be happy to include that in the staff report. But again, based on our review of everything, we do not believe that it qualifies. Now, ultimately, your commission can make that decision, which is within your purview, but we would just request that you ask for a continuance to a set date to specify that you would like staff to continue to accept any additional information provided by the project applicant, and to also continue to evaluate and bring back additional information to your commission regarding what are the absolute requirements to qualify for vested rights, and what would that mean if that vested rights were determined. That part I can absolutely make sure that we incorporate into any information that we got back. I would ask, given the level of case law that needs to be done in some of this and extended, I don't even believe a month is enough time. I would ask that this commission be continues to at least 6 weeks, potentially 8 weeks, to allow staff sufficient time to gather that information to incorporate into a presentation that we would bring back to you. So again, a date would be required. If today is end of February, at the very least, I would ask that it not come back in March, but in one of your April meetings. So the first one would be April 10th, or the second one would be 14th or 28th would be my request, to give staff sufficient time to continue to evaluate and be able to respond to those questions.
Okay, so I will make a motion to continue the hearing, and I will go even further to May 12th. Allow staff to accept any information, to bring back information from the applicant to qualify vested rights, and if vested rights are determined.
Not during a motion, you cannot ask a question.
We need a second. No one else? I'll second that.
Two ayes, 2 noes, 1 absent. Motion is.
So to clarify what that means, and council, correct me if I am wrong, but this action needs a definitive decision one way or the other. So it either needs to be approved, denied, or continued, and it will require 3 votes to make any of those particular motions. There is no way that we can move forward with anything based on the vote that just happened. So based on that, your commission needs to continue discussions until you can come up with an additional motion and second that could be voted on by at least 3 members of the commission.
Mr. Judge.
I'll be first to jump in. The issue I'm having, even for continuance, is I think the issue I see is, even if a vested right is brought, and correct me if I'm wrong, Mr. Hall or Mr. Murphy, is if it's brought up to where even a vested right can be proved, the concern would be is there's a 3-pronged process to make sure that it could be mined. And one of those was the allowance of the, losing my train of thought for the word, the reclamation of that was issued and approved back in, what was it, 89, or the original CUP was approved. So I don't think with today's current conditions and today's current issues we have with CEQA and those type of issues that we're dealing with today, that could hold up, and we would be able to vote on that and say that was still valid. I think the staff would have to update that, and I think please correct me if I'm wrong, but when they do that, it must be reevaluated through the secret process. Is that correct?
Commissioner Judge, through the chair, that is a possibility. Can't tell you definitively today that there would not need to be any changes to that reclamation plan. And if there were, then clearly that's subject to CEQA. If there were not, then there would not be, and they would continue to go forward. But I cannot tell you today definitively that the existing reclamation plan, even if we had the financial assurance, is still in place and adequate and would not need to be amended. I cannot tell you that today without doing additional research.
Commissioner Ashley?
Mr. Murphy, does that include amendments? So now we're getting in splitting hairs here, but amendments to that reclamation plan, including the number, the amount of dollars that have to be put aside, does that constitute a change that didn't be subject to CEQA? Because I can tell you right now, I do a bunch of dirt work in our business. $81,000 is not going to cover the amount of work that needs to be done there to fully reclaim this under SMARA.
Commissioner Ashley, through the chair, to that point, my staff also helped to advise that these reassurances are supposed to be updated on an annual basis as well. And we have not had an updated annual basis in terms of the financial assurance. It's just the one that's been in place. So again, I cannot answer that question definitively at this particular time.
I'll add, you seem to be only concerned about the dollar figure going up. That would probably be ministerial. I mean, just my off the cuff, which would mean it would be ministerial and therefore not subject to CEQA. But to go back to the bigger point, I think you really should, and my recommendation to the board now would be to continue this, because we just do not have enough information in the record. I mean, we've heard an impassioned presentation, but there's one element of the presentation that we need to have drilled down on more. And, you know, if this board grants the applicant, that doesn't mean that the applicant doesn't have somebody then take him into court and challenge the action of this board, and we don't have the record to support that. By giving that continuance, you get us time to improve that record. And when I say us, some of it is staff, but the preponderance of the evidence standard is on the applicant to make that in the record. So.
Thank you, Mr. Hall. That's been the chair's sort of opinion about this too. We just don't have enough information, and yet there seems to be a possibility of vested right, and I don't want to do the applicant wrong here by not fully acting upon that, based upon all information, because there is, to me, a possibility that this was not done right in the first place, and therefore we need to correct that as best we can, or if we can. So with that in mind, I request a second motion maybe to move forward with this.
I'll just say one more thing. I'm a huge proponent of property rights, so don't take away from my comments. I just have been down this CEQA path enough to understand where you get your tail spanked, and trying a lower tier CEQA document, if you're put into that realm of CEQA review, you probably won't come out on the side that you would like to. So I'm trying to give you some predictability going forward. I think your comments about a market that is prime, those are only going to become more true in the future. And so I'm trying to help with the predictability of it. I'm fully willing, certainly with the input from Mr. Hall, I'm fully willing to give you every chance to come back in and make your case, so we have a better record and could support you going forward. So I would be willing to make a motion for continuance.
I would like to throw my 2 cents in too, and I would just want to echo Commissioner Ashley's points. The same point I want to clarify is too is, you know, I'm a proponent of wanting this to work for you and be successful. I just don't want to put our board or ourselves in a predicament to where we do something that basically comes back to bite us for not following the right procedures. And so with that, you know, I think your opportunity to mine your property is valid, and you should be able to do that. And you have a path of getting there, which is the impact report right now, currently, which if you're supporting not to do that, you know, we want to give you opportunity as well too. So I just want to clarify that as well. And if with that, I would also say I have no problem with not picking another opportunity to keep bringing back to our board again. So I think a new motion has to be made, and I think I would turn to Commissioner Ashley. You want to make that motion?
Yeah, I will follow on Commissioner Skidmore earlier, make a motion for continuance until May, whatever date she said, 10th, I say, somewhere around in there. 12th, that was close.
I'll second that motion.
Call the vote.
4 ayes, 1 absent, motion carries.
Can the applicant speak again?
No, they cannot, can they? Public comment's been closed.
Yeah, that's true.
Yeah.
This is true.
I'm just seeking clarification.
Staff would
Yeah,
be happy to
staff would-
talk to him afterwards to
Okay.
let him know what that means and some of the things along those lines.
Thank you, Mr. Murphy. We'll forward that. That in mind, we have concluded our agenda. Motion to adjourn.
Motion?
Second.
All ayes?
Aye.
Aye.
Aye.